Hello, everyone. For folks joining, we'll get started in about 1 minute. Good afternoon, everyone. Welcome to the Environmental Law Institute's annual Supreme Court Review and Preview webinar for 2023. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. I want to give everyone a warm welcome to today's event, and thank you so much for joining us today. We appreciate your time and engagement. Today's webinar is an annual program ELI holds in advance of the first Monday of October. Next Monday, the Supreme Court is to formally close the October term of 2022 and begin the October term for 2023. Today's panelists will offer an overview of key rulings and major takeaways from the court's last term, focusing on decisions with significant implications for environmental law. They will then turn to cases that have been granted review or are likely to be considered by the justices in the upcoming term. We have 3 returning speakers and 1 new speaker this year. Thank you so much to Jay, Robert, and Sharon for returning this year, and thank you to Gerald for joining us for this year's program. We're so excited to have you all here, and we're so thankful for your time and energy preparing for this program. We will be saving time at the end of today's program for questions from the audience. So for those tuning in live, if you have any questions, please put them in the Q&A box. You don't need to wait until the end of the program, though. Please submit them as soon as you think of them through Zoom's Q&A function. The chat will also be open for you to post any observations throughout the event, but we request that you please put any questions you would like our speakers to address in the Q&A box rather than the chat. Should you have any technical issues during the webinar, please message the ELI team or email events@eli.org. This webinar will be recorded, so if you're unable to view the entire program, you'll be able to find it on ELI's event webpage within a few business days of the event. We're also going to keep this one public for a couple of weeks given the holiday today. And with that, I will hand things over to our wonderful moderator, Jay Austin. Jay is a senior attorney at ELI, and he's also the editor-in-chief of ELI's flagship journal, the Environmental Law Reporter. Jay, I will hand things over to you. Thank you so much, everybody.
Well, thanks, Madison. Good morning from rainy Portland, Oregon. Good afternoon to many of you, and welcome to this annual Supreme Court Review and Preview. It's been a little over a year since the court decided the West Virginia Clean Air Act major questions case. It's been only 4 months since it issued its most impactful Clean Water Act decision ever. As Madison points out, first Monday is just a week away, and there still seems to be a lot more to come. Lately, I've found that I've been unlearning environmental and administrative law faster than I can manage to learn it. So to help me out today, we are bringing in 3 panelists who are leading experts in those fields. First, we have Sharon Jacobs, a professor of law at Berkeley Law School, where she teaches energy law, environmental law, and administrative law. Morning, Sharon. Gerald Torres is professor of environmental justice at the Yale School of the Environment and a professor of law at Yale Law School. Gerald, welcome this year to our discussion. We're happy to have you join us. And Robert Percival is the Robert F. Stanton Professor of Law at the University of Maryland's Carey School of Law, and he directs the environmental law program there. Bob also was a law clerk for Justice Byron White. I've asked each of our panelists to start by taking up to 10 minutes to highlight a decision or two from the court's past term. We'll then pause for panel discussion on the just concluded term with some focus on the Sackett Wetlands decision and its larger implications. And we'll then turn to a preview of the upcoming term and a discussion of things to come. As Madison said, we will try to leave time at the end for audience Q&A, so please do enter your questions into that box, not the chat, and we'll try to get to as many as we can. So starting off with our review of last term, Sharon, would you kick us off with the National Pork Producers case, a California case, and set of issues for you?
I would be delighted, and I'm coming to you this morning from California, so it seems appropriate. I'm going to start by talking about this National Pork Producers Council versus Roth case decided in May of this year. It's a case about animal welfare and public health, but it's also a case about the so-called Dormant Commerce Clause, a doctrine that's been used to limit states' ability to legislate, and one that I think could have important implications for other environmental and even energy statutes and regulations going forward. So it made the list. The facts of this case are pretty straightforward. California, as most of you probably know, has the initiative process, which is a version of direct democracy where citizens here can qualify initiatives for the ballot. Those initiatives can become law. We adopted one such initiative here in 2018 called Proposition 12 with about a 63% share of the vote. So it was quite popular, became part of the Health and Safety Code. It's a law that prevents in-state sale of pork products from pigs that were confined in a cruel manner. And the statute defines cruelty as including preventing the pigs from lying down, standing up, fully extending their limbs, turning around freely. Would essentially eliminate sales of pork if producers use gestation crates for pigs, which are very, very small cage-like structures that prevent pigs from turning around. But they're widely used across the industry. The goals of this initiative were, of course, to prevent animal cruelty, but proponents also suggested there would be health benefits for consumers of shifting methods. The challenge was brought by two out-of-state organizations representing pork producers, and their argument was that the law violated the Dormant Commerce Clause. This is, of course, the doctrine derived from the Commerce Clause of the Constitution, the implication being that if Congress gave power to regulate interstate, if Congress was given the power to regulate interstate commerce, the states no longer have that power. The really tricky part, of course, is trying to figure out when a state law constitutes regulation of interstate commerce. And prior to the decision in National Pork Producers, there were a few ways that a law could run afoul of the Dormant Commerce Clause. One is that it could expressly discriminate against out-of-state producers in favor of in-state business. One is that it could, another is it could regulate outside of a state's borders. This is the so-called extraterritoriality doctrine. And then third, if neither of those applied, the law could still violate the Dormant Commerce Clause if it imposed a substantial burden on interstate commerce that it was clearly excessive in light of the local benefits of the law. This is what's become known as the so-called Pike balancing test. The petitioners here weren't alleging intentional discrimination, and they acknowledged that the burdens on in-state pork producers were facially the same as burdens on out-of-state pork producers, but the catch is that most of the pork sold in California comes from out of state. And California is a huge market. It accounts for somewhere between 10 and 15% of pork sales nationwide. In addition, because of the way the pork market and pork processing works, apparently it's really hard to figure out what pork is destined for what state. So the out-of-state producers claim they're going to effectively have to change their practices across the board to comply with California's law. And they say that that constitutes extraterritorial regulation, that California is trying to regulate operations in states that have nothing to do with California, where the product isn't even going to California. The producers are also claiming that under Pike balancing, the local benefits of Prop 12 don't outweigh the burdens that the law imposes on interstate commerce. They say the local benefits are illusory, right? The moral benefits are dubious, the health benefits are dubious, and the out-of-state burdens are significant. It's going to increase their cost dramatically. That'll be passed on to consumers. So below, the district court dismissed the challenge for a failure to state a claim. The Ninth Circuit affirmed. And right here we have the Supreme Court affirming the dismissal of the challenge by a 5-4 vote, but the opinion is a mess. It's highly fractured, features some unusual coalitions as well. Justice Gorsuch writes for the majority for many pieces of his opinion, but not all of the pieces of his opinion. And the pieces that have a majority say essentially, let's simplify the test for the Dormant Commerce Clause. The core of it is that states shall not, through their laws, show any kind of economic protectionism, calls this the anti-discrimination principle. Not a big fan of the extraterritoriality argument that the pork producers were making, says the cases in this area do not establish anything like an almost per se rule that extraterritorial regulation violates the Dormant Commerce Clause. They do nothing of the kind. Most state laws, he says, have the practical effect of controlling at least some extraterritorial behavior to some extent. So really can't use that extraterritoriality test as an effective test for violations of the Dormant Commerce Clause without invalidating whole swaths of state regulation. Leaves the door open for claims of extraterritorial regulation, but just a crack. Right? There's certainly nothing now close to a per se rule that laws with extraterritorial effects violate the Dormant Commerce Clause. And then also a majority for the position on pike balancing, that it doesn't make sense to think about pike balancing separately from the anti-discrimination principle, that pike really reminds us that a law's practical effects could disclose the presence of a discriminatory purpose. And that laws without much local benefit at all, but that impose a substantial burden on interstate commerce may in fact be designed to discriminate. The court finds that there was no discrimination here under their anti-discrimination principle. It says, look, companies that choose to sell their products in various states normally have to comply with the law in those various states. We have a long history of state animal welfare laws, just like this one. So the California law survives. We get a lot of interesting discussion in the sections of the opinion, the Gorsuch opinion, that don't have a majority, about where certain members of the court would go further in changing the test for the Dormant Commerce Clause. So there's an interesting section where Justice Gorsuch, joined by Justice Thomas and sort of by Justice Barrett, says that courts are just not well suited to do the kind of benefit cost balancing required by pike. That when we're dealing with incommensurable values, and here think of things like, the moral benefits of the law to Californians, when we're dealing with those types of incommensurable values, these are ultimately policy choices. This is not where courts should be getting involved. We should give more leeway to the states. Justice Gorsuch, skeptical of pike balancing, full stop. Can't get a majority for that proposition, but that is something that at least several members of the court are wrestling with. And then there's this question of how you show a burden, right, in light of those challenges. We do have 6 votes, and I want to, Justice Kavanaugh is careful to call this out in his separate opinion, 6 votes for keeping the pike balancing analysis as part of the Dormant Commerce Clause analysis, including a separate opinion by Justice Sotomayor, joined by Justice Kagan, says won't close the door to invalidation of some state laws that are genuinely non-discriminatory if they impose significant burdens on commerce. Justice Barrett, writing separately, to emphasize that, sure, the burdens here are incommensurable and hard to balance, but that's not always going to be the case, right? There are plenty of benefits and burdens that courts are going to be well qualified to assess and balance. And then Chief Justice Roberts, writing separately, joined by Justice Alito, Justice Kavanaugh, and Justice Jackson. I told you there were strange coalitions in this case. Has a different view. They all have a different view on pike. They think it's still quite important, right? That it's still possible even to weigh seemingly incommensurable things. And then finally, Justice Kavanaugh, writing separately, not only to note that pike is still part of the Dormant Commerce Clause, but that California here has attempted to unilaterally impose its moral and policy preferences for pig farming and pork production on the rest of the nation, kind of calling out a parade of horribles about the kinds of laws we can see coming down the pike in the future, no pun intended, if this type of law is allowed to stand and doesn't violate the Dormant Commerce Clause. So he foresees a new era where states shutter their markets to goods produced in a way that offends their moral or policy preferences, and kind of a shutdown of interstate commerce. So, the upshot is that Prop 12 survives. The Dormant Commerce Clause analysis is slightly altered to de-emphasize extraterritoriality, maybe limit pike balancing in some ways where there are incommensurable principles, but of course there aren't enough votes to really tell what's happening on pike balancing. Just a few observations about implications very quickly. One is that there doesn't seem to be the kind of judicial self-aggrandizement here that we're used to seeing from this court. So in other words, this is not an aggressive reading of the Dormant Commerce Clause in a way that would allow the court to insert itself into policy debates around the country, invalidating laws that it thinks go too far in affecting commerce. And this is anything a pulling back from an aggressive version of Dormant Commerce Clause analysis. This is going to leave states like California, but also other states, much more room to shape policy around the kinds of products they want to see in their state. That means more flexibility to enact state environmental or energy laws that affect out-of-state actors. I think of things here like plastic bag bans or the low carbon fuel standard that's already been upheld in California against a Dormant Commerce Clause challenge. And then I just think it's interesting the kind of back and forth we see among the justices here about how to assess the incommensurable benefits and burdens that pike balancing requires. We haven't seen that kind of humility or skepticism about judicial ability in the context of arbitrary and capricious review looking at cost-benefit analysis, for example, right? So does that mean that judges are also going to be ill-suited to second guess an agency's choices when it comes to cost-benefit analysis? So I'm just really curious about how much judicial humility there is in this opinion, where we'll see it in other places. Back to you, Jay.
Well, thanks, Sharon, for helping make sense of that one. It is indeed an odd coalition, odd lineup of justices. It'll be interesting to see how well it hangs together in other environmental law type cases. Let me toss out one question that popped up specific to this case. I think we've got time to address that on the fly, asking if there were amicus briefs from other industries in the case with regard to Dormant Commerce Clause issues. The questioner uses the example of textbook manufacturers, which apparently are largely centered in Texas, but I imagine there are any number of other industries that might have seen their interests at stake in this decision.
There were a lot of amicus briefs in this case, and certainly they came from organizations whose interests extended far beyond animal welfare and animal production, worker safety advocates, the National League of Cities, professors interested in trade law. So, I think it's fair to say that everyone understands that this case is going to have implications far beyond health and safety regulation.
And potentially on some more contentious, controversial interstate issues as well when you bring in the moral dimension. Thank you. Next up, we have Gerald, who's going to talk about Arizona versus Navajo Nation, important decision on treaty water rights.
Thank you, Jay. I was going to say the introductory treatment of the cases by Sharon makes you think, God, we could spend the whole hour just on those. Those are raising incredibly important issues. The case of Arizona against Navajo Nation involved the question of whether the United States needs to assist the Navajo Nation in securing the rights to water that it claimed were guaranteed to it in the 1868 treaty that they signed with the United States. Let me just say that this litigation actually started in 1953. So it's been a long series of efforts. I don't think we're done yet, but it involved two really important questions. And then I want to spend a little time after I talk about those to the challenge that Justice Thomas posed in his concurrence. So the first issue is the issue of the reserved water rights. So what's called the Winters Doctrine in federal Indian law says that when land is set aside for tribes, one of the things that accompanies that land that's set aside is the water necessary to make the land productive. The court in Winters intervened in a stream adjudication to ensure that the tribes would, who were excluded from that adjudication, would have their share of water. One of the issues in this case is, of course, arises over the disposition of water to the Colorado And as you know, the Colorado River states were just involved in kind of comprehensive negotiations over that. One of the points the Navajo made is in the distribution of the water rights to the Colorado River, they were left out. And since their interests are represented by the federal government, the argument they were making was that the federal government has an obligation to represent the water claims that the Navajo Nation would make, consistent with the needs and the promises that were made in the Treaty of 1868. That implicated, as the Winters Doctrine itself does, the idea that the federal government has a trust obligation in relationship to tribes to manage resources, a variety of obligations. But in essence, it stands as a trustee for the tribes. In this case, the tribe was saying the United States violated the trust duty by failing to vigorously represent the claims of the nation in the adjudication of the water rights that would have benefited the reservation as a whole. The way it was characterized in the decision is that the Navajo were requesting affirmative steps on the part of the federal government to ensure that they would have adequate water for the needs of the reservation. Justice Kavanaugh, in his opinion, suggested that this might include pipelines and pumps and various other infrastructure for the delivery of water. But of course, all of those questions are merely secondary questions to the principal issue of whether the Navajo's percentage of water that is due to the Navajo has been correctly adjudicated. That was at the heart of it, what the Navajo Nation was claiming, that the adjudication of the water rights had left the Navajo Nation short of what it needed, and actually short of what was promised in the treaty. Okay, so let's step back. The question is whether the treaty speaks directly to the needs of the Navajo. The answer is that the treaty creates a trust obligation on the part of the United States to ensure that, in light of the Winters, that the tribe would have sufficient water for the needs that were outlined in the treaty. Does the treaty require the United States to build pipelines and pumps and wells, et cetera? No. The treaty merely creates an obligation on the part of the United States to ensure that the tribe has adequate access to the resources necessary to make the Navajo function as the homeland that it was designed to function as. So the characterization of the request by the Navajo is critical, because one of the requirements in the application of the trust duty is whether there is a specific statute, specific law that would support the claim the tribe is making. And so in a series of cases, right, the Supreme Court decided that there wasn't a bare trust, that is kind of a naked trust obligation, but that the obligation of the trust had to be tied to certain assurances that the federal government had made, either through statute or regulation or some other legally binding hook. What Kavanaugh and what Thomas in his concurrence point to is the lack of any specific language that would obligate the federal government to undertake protection of additional rights beyond those the Navajo currently have. One of the problems with that analysis is that it takes you away from the question of what the treaty itself obligated the federal government to do. The question that has to be answered first is whether the federal government acted with sufficient vigor to protect the claims of the Navajo to river to support the reservation that was created. Now, it's important to remember some of the history is that one of the complaints of the Navajo when they were initially dislocated before they were allowed to return to some of their homelands was that the place that they had been dislocated to, Bosque Redondo, was in fact poorly suited to the kind of agriculture the tribe wanted to undertake, and it had bad water. So one of the things that would have been at the top of mind for the tribal negotiators would have been access to, and in fact, there's some history that indicates that they were concerned about access to good water. Notwithstanding those claims, notwithstanding Winters, the majority opinion, the opinion of the court, turned on whether there was a specific legal obligation that would require the federal government to take affirmative steps to protect the water claims of the Navajo. Because they found none, they held against they reversed the Ninth Circuit and held against the Navajo. I want to turn to Thomas's concurrence though briefly, because he makes 2 points that are potentially far-reaching. One is he thinks that the idea of the trust at all is misplaced, that the language of trust obligations arising out of the relationship between the federal government and the tribes, it has no constitutional warrant. It's been used loosely. It is used as though it represented something like a common law trust when it does nothing of the type. There are obligations that are statutorily required of the federal government, and that the court ought to focus on those. But that the idea that there is this trust relationship established between the tribes and the federal government, Thomas is troubled by that idea. He thinks that it promises too much, it's imprecise, and it is, to use his language, free-floating above the Constitution and not rooted. He goes one step further, though. He says not only is there no warrant, no constitutional warrant for this trust duty, he says that what have come to be called the canons of Indian construction, the Indian canons of construction in statutory construction and treaty construction, that the court has historically used in analyzing statutes and treaties that apply to the tribes, grows out of the trust duty and sets out a separate interpretive framework. He wants to reject that interpretive framework because it's rooted in the trust duty. The trust duty has no constitutional warrant, and thus the application of these interpretive guidelines that the Supreme Court has adopted aren't sound either. Justice Gorsuch, as you might suspect, had a long and strong dissent. I think he makes the point very clearly that if you tee up the ball wrong, you're going to hit it wrong. And he accuses Kavanaugh of teeing up the wrong question. He, of course, relies heavily on the history. And he, unlike Thomas, recognizes that the trust duty arises out of the constitutionally driven relationship that the court identified in the early Indian cases. So where do we stand? The Navajo Nation is going to continue to push the claims that it has for additional water and we'll see how that turns out. It started in 1953. It's not over yet. Thanks.
Thanks, Gerald. And just quickly, I think I missed at the top of your presentation, how many votes did the Thomas concurrence attract?
How many votes did the Thomas concurrence? I think just his. Kavanaugh, Alito, Barrett, and Roberts joined the majority opinion. Thomas joined it, but filed a concurrence. Gorsuch, Sotomayor, and Kagan and Jackson dissented. And
Solo concurrence. Thank you.
Yeah, solo concurrence, exactly. And I think he
broad indeed.
Yeah, the concurrence was to continue his attempt to rewrite federal Indian law, which he's been doing since at least Lara.
Right, many thanks. Well, turning to Bob, people who watched this webinar last year might recall that Bob filed a fairly dramatic report fresh from the steps of the Supreme Court, having watched the oral argument in Sackett. And so we're able to get almost real-time details on that. Well, now the case has been decided. It is quite impactful, meaningful, as I think we anticipated. Bob, what do you want to tell us about that?
Yeah, this case is really a doozy, and it's had a very long history. It involves the reach of federal authority under Section 404 of the Clean Water Act that requires a permit to deposit dredged or filled material in wetlands. When the court first confronted this issue in 1985 in U.S. versus Riverside Bayview Homes, it unanimously deferred to the regulations that the Corps had adopted that had, many thought, essentially been ratified quite quickly by Congress in the 1977 amendments. And in that unanimous decision, Justice White, writing for the court, cautioned against doing precisely what Justice Alito did in his 5-4 majority opinion here. He said, quote, "On a purely linguistic level, it may appear unreasonable to classify lands, wet or otherwise, as waters. Such a simplistic response, however, does justice neither to the problem faced by the Corps in defining the scope of its authority under Section 404, nor to the realities of the problem of water pollution that the Clean Water Act was intended to combat." What ends up happening in this case is based on an extraordinarily narrow interpretation of the word waters in waters of the U.S., the jurisdictional hook for Section 404, and also for Section 402's reach of the Clean Water Act to discharges to other surface waters. The court significantly rewrites the Clean Water Act. Now, following Riverside Bayview, in 2001, the court for the first time restricted federal jurisdiction over wetlands in the Solid Waste Agency of Northern Cook County versus U.S. Army Corps of Engineers decision. In another 5-4 decision, the court ruled that a truly isolated wetland that was not near navigable waters could not be subject to federal jurisdiction just because of the presence of migratory birds. Then mass confusion ensued following the Lopez decision in 2005 that for the first time struck down a federal statute, the Gun-Free School Zones Act, on the grounds that it exceeded Congress's commerce power. In a case called Rapanos versus U.S., where you had wetlands adjacent to a non-navigable tributary of navigable waters, the court split 4-1-4. In a plurality opinion by Justice Scalia, Scalia argued that a dictionary definition of waters meant that only waters with continuous surface connections could be regulated under the Clean Water Act. 4 justices deferred to the Corps, and then Justice Kennedy, alone among the justices, said that he didn't accept either of those positions. Instead, he developed his own significant nexus test and argued that there should be a case-by-case determination of whether or not the wetlands had a significant nexus to navigable waters so that pollution of them could affect the navigable waters. All 8 other justices rejected the significant nexus test, but it became de facto the way you would have to get the crucial 5th vote to uphold federal jurisdiction in the case. Now, one other interesting thing Scalia said, however, when criticized that his opinion logically could also cut back on Section 402 jurisdiction over discharges to surface waters, non-wetlands, he argued that the act did not say that it only banned direct discharges to surface waters. And so you couldn't just move your pipe upstream and accomplish the same pollution without getting a 402 permit. Now, what ensued then was mass confusion for well over a decade as courts tried to apply the Rapanos decision. In 2012, Sackett actually first came before the Supreme Court. A couple was trying to build a home on property right next to Priest Lake in northern Idaho, and they had tried to fill it without getting a 404 permit, and the Corps had issued an administrative compliance order telling them to stop. They went to the Supreme Court and argued that they should be able to get pre-enforcement judicial review of an administrative compliance order, and the court ruled unanimously that they could do so. When the case went back down through the courts, and particularly the Ninth Circuit, applied essentially the significant nexus test, which had been embraced by the Obama administration when they promulgated the WOTUS rule. And to add more confusion, there was a dispute over whether challenges to the WOTUS rule should first go to the courts of appeal or to the district courts, and that precipitated another Supreme Court decision, National Association of Manufacturers versus Department of Defense, saying since this wasn't really a rule but clarifying the extent of federal jurisdiction, those challenges should first be filed in the district court. So you had all this district court litigation reaching contradictory results at times, and the state of federal jurisdiction varied from part of the country to part of the country. Then the Trump administration came in and did its own navigable waters protection rule, which greatly cut back on federal jurisdiction, although arguably even their rule would have covered the Sackett's property. So Sackett comes before the Supreme Court, and we end up getting a 5-4 decision written by Justice Alito. He has nothing but harsh criticism and contempt for the Clean Water Act, Section 404, talks about how the penalties for even inadvertent filling of wetlands could be potentially crushing both criminal and civil penalties. And as a result, tries to justify using something even narrower than Justice Scalia's plurality opinion in Rapanos, and comes to the conclusion that the only wetlands that can be regulated are first, if they're adjacent to water constituting water of the United States, that means a relatively permanent body of water connected to traditional interstate navigable waters. The wetlands themselves must be that. And second, that the wetland has a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins. Now, Justice Kavanaugh joins the 3 liberal justices, Kagan, Sotomayor, and Jackson, in dissent. And their argument is that the act has essentially been rewritten by the Supreme Court because the act states by its very terms that adjacent wetlands can be regulated. And yet what the majority is saying is that the adjacent wetlands have to be adjoining. And Justice Kagan says adjacent means in the neighborhood. They doesn't mean that it has to be adjoining. And she says, just like the Kagan in her dissent says that it's just like West Virginia versus EPA, where the court is imposing its own policy preferences and not Congress's, and is effectively rewriting the act. Now, it's interesting that in the county of Maui, decision in 2020, both Chief Justice Roberts and Justice Kennedy had joined the 4 liberal justices at the time to avoid blowing a huge hole in Section 402 based on Scalia's observation in Rapanos that it doesn't have to be a direct discharge to be covered by 402, saying that Maui had to get a permit before it could discharge its wastewater from a sewage treatment plant through groundwater, which then quite quickly passed into the ocean, which was clearly part of the waters of the US. And Justice Kavanaugh then wrote a concurrence saying, I'm just following Justice Scalia in Rapanos to that extent. That would have blown a major hole in the Clean Water Act, but the other conservative judges, particularly Alito and Gorsuch and Thomas, were willing to blow a hole that would say, as long as the pipe isn't directly in the water, you don't need to get a 402 permit. Now, finally, one other interesting fact about this case, I noticed that in his majority opinion, Alito, in order to talk about the crushing consequences of Section 404, cites the Borden Ranch decision, a case from actually 2002. And what's interesting about that case is that in that case, a wealthy landowner hired a deep ripping machine to blow apart the clay pan underneath a wetland in order to convert it from a wetland into a place where he could grow grapes. And he had bragged to the court that he was going to beat them in court because he was a personal friend of Justice Kennedy. Now, when the case got to the Supreme Court, Justice Kennedy had to recuse himself because he was a close personal friend. Query Justice Alito's recent statement saying the fact that a lawyer is about to hear before him in another case who interviewed him in the Wall Street Journal has written gushing op-eds about Alito should not be grounds for recusal because we all have friends and ex-law clerks and acquaintances, and we know who's written favorable things about us, but we maintain our neutrality. So this is likely to have huge consequences for the Section 404 program.
Thanks, Bob. We could spend a lot of time on Sackett, easily the rest of our time. In fact, ELI's had 2 prior webinars on Sackett, one on the implications of the decision when it first hit, and one quite recently on the implications of how EPA is addressing the decision through its revised rule. So for now, I just kind of want to zoom the lens out a little bit and addressing in particular Sharon and Gerald before coming back to Bob with a case-specific question. Bob, you had pointed out something I found quite striking about Sackett, which is that Justice Kagan, in her concurrence in the judgment that essentially serves as a dissent, literally cut and pasted an entire paragraph of her decision from last year's West Virginia case, saying, I'm only going to change one word here from Clean Air Act to Clean Water Act, and my same dissent effectively stands. I thought that was really emblematic of a lot of the recent disagreement among the justices, even tension, which has spilled over into a lot of other areas as well. So I'd be interested in Sharon and Gerald's take. In very broad terms, why is she yoking those 2 cases together? What, in her view, is sort of the cardinal sin that the majority's been committing here? Sharon,
Well,
you want to
sure.
jump in?
So, you know, I have a special interest in Justice Kagan. I should disclose that she was my administrative law professor. So I am a big fan of her opinions and the way she crafts them. And I also thought this was interesting. I mean, I think one thing that she's calling out here is the use of substantive canons by canons of interpretation by ostensibly textualist judges to put a thumb on the scale for certain outcomes. So in West Virginia versus EPA, it was the new major questions doctrine, which we may have a chance to return to. In Sackett, it's canons to do with federalism and respect for states. But the idea that these canons, some of which have been around for a long time, some of which are very new, can be used to kind of tilt the analysis before statutory analysis even begins in the guise that we know it. In other words, before kind of a classic textual analysis of the provisions in the Clean Water Act or in the Clean Air Act even starts, I think that's why she's emphasizing the link between these two cases and warning against that kind of, as she sees it, tilted statutory construction.
Gerald, your thoughts?
Yeah, I mean, I don't really have anything to add. I mean, that's exactly right. That's exactly right. One of the a perhaps less cautious way to put it is you know, she's saying, look, I know a willful court when I see it, and you know, that's, I think being able to make that easy substitution is a demonstration, and that's, you know, unfortunately, I think where we are.
And maybe if I could just add one more quick thing here, you know, taking us back to sort of the focus on environmental regulations specifically, you know, she makes the important point that a lot of these canons are, they're general, right, in nature. They're designed to be general, even the ones that are specifically tailored to particular areas like lenity, right? They're being applied in a very general way, which is in direct contradiction to kind of the majesty of these environmental statutes, right? The specificity of these statutes, the care that Congress took in the 1970s, right, especially to create statutes to solve big environmental problems, taking a lot of care in how they did so. And, you know, so she sees the contrast between using these big general canons and the really sort of clarity, the real clarity of Congress's intention in crafting these statutes to address actual real world problems. You know, there's a saying in statutory interpretation that the specific governs the general. It's a version of that, I think, right? It's not exactly the same, but the idea is, let's look at what Congress did in the Clean Air Act and the Clean Water Act and these other statutes, and let's honor that, right? As opposed to invoking big doctrines that have little, if anything, to do with environmental protection.
Yeah, if I can underline that point just briefly, I mean, it's important to recognize that the acts were amended, right, in the 70s, right, to add greater clarity and for the Congress to explicitly say what it meant, right, so that paying attention to what Congress actually says, if you're a textualist, you would think that would take you know, priority. I agree.
And with respect to the Clean Water Act, Congress's statement of goals is just absolutely breathtakingly broad to restore the chemical, physical, and biological integrity of the nation's waters. It'd be hard to be much broader than that. And, you know, that certainly validates the claim by Justice Kagan that the court is totally ignoring the real purpose of the statute and trying to interpret it.
As well as the sort of scientific and ecological values that underlay that statement of purpose.
I mean, if I can make one little point,
Please.
you know, which is, it also ignores the incredible progress that the Clean Water Act has produced, right? I mean, put aside the legal arguments. In fact, if you look at what the law has actually accomplished, it's actually been quite effective. And so it's been effective because Congress outlined the approach it wanted the agency to take in regulating the quality of America's waters. And, you know, so, you know, to put that in jeopardy is actually breathtaking.
Well, thank you all. We're getting numerous questions on SACIT in the Q&A, and I will try to hold some of those and see if we can't come back to them at the end of this webinar. But I also commend to folks the two previous ELI webinars I mentioned on the topic, which delved quite deeply into the potential impacts and the details. And maybe Madison or Sarah could drop the links to those events in the chat for people's reference. We need to move on to the preview portion of the coming term. So really back to you, Bob. This is kind of, SACIT is sort of a pivotal decision in that regard. You mentioned rightly, I think, Justice White's unanimous 9-0 opinion in the Riverside Bayview case back in 1985, the first holding that wetlands could be included in waters of the United States. But in addition to that statutory interpretation, that decision also hinged on deferring to an agency definition of adjacent wetlands, which, at least to my eye, may no longer be wholly compatible with Justice Alito's new test in Sackett. So what's going on there? Is the court essentially, in this move from 9-0 to 5-4 over 40 years, is the court essentially overturning Riverside Bayview without saying so? And if so, what does that say about the future of Chevron deference, which I think in turn brings us into the upcoming term?
Yeah, it's certainly, one of the big cases that the court's already granted cert on. On May 1st, the court granted cert in Loper Bright Enterprises versus Raimundo. And what was interesting about that grant, the case involves the question of the validity of a regulation by the Department of Commerce requiring fishing companies to bear some of the costs of having the monitors that are legally required by the Magnuson-Stevens Act to be on their boats to make sure they fish in accordance with law. And the court only granted cert on the question that was phrased as, should Chevron be overruled or reinterpreted in a much narrower way? So it looks like for the first time, the court has decided to bite the bullet and make a judgment about Chevron. Since all 6 of the conservatives on the court, or at least 5 of them, I don't know how you count Roberts on that, have criticized Chevron. If they want to overturn it, they certainly could. Now, I think Roberts is the one who would try to be a little cautious. The interesting thing about Sackett is that in Rapanos, Roberts, who had just been on the court 1 year and at his confirmation hearings had said, I hate these fractured decisions, I want to unify the court, had written a concurrence that said, we wouldn't have such a confusing result in Rapanos if the court had adopted its own definition of waters of the US. Well, that's exactly what both the Obama and Trump administrations did. And now the Biden administration is doing it also. And the court almost completely ignored that. And there's no discussion in Sackett of the validity of those regulations at all. So clearly no deference. I've argued for quite a while that Chevron's a dead man walking in the Supreme Court because knowing that a majority of the justices don't like it, few advocates cite Chevron. That's still not true in the lower courts. It still has some purchase there. But we'll see in this case, which probably won't be argued until the spring because cert wasn't granted until May 1st, if the court finally decides to bite the bullet and overturn Chevron. Now, what's so ironic, of course, is that when Chevron was decided initially, it was a defeat for environmentalists because it was during the Reagan administration when they had adopted the bubble policy that made it easier for corporations to avoid having to install advanced air pollution controls. And many have argued, well, what's really changed? And you see Justice Thomas having admitted that, in fact, he was once a fan of Chevron, as was Justice Scalia, but now he doesn't like it. Maybe it depends on what administration's in power. If it's one that's rolling back regulations, the court's happy to defer to it. But if it's one that is trying to implement the law with broad regulations, then the current conservative majority doesn't want to give it any deference at all.
Sharon, Gerald, any thoughts on the future of Chevron?
I think Bob's pretty much, I'm not going to disagree with him.
I mean, I think maybe what I'll do is link these conversations about the future of Chevron to a couple of other cases that are coming up next term that also threaten the operations and even the existence, I think, of parts of the administrative state, parts of administration. And I think that the Loper case is a symptom of this overall movement on the court to question, to challenge what many of us had thought had become sort of settled wisdom, settled doctrine when it comes to agencies and administrative law. Obviously, rolling back Chevron would shift expectations that have been in place since well before the 1984 Chevron decision, insofar as Chevron, at least according to the court that wrote it, was just trying to codify existing practice in the way the courts treat agency interpretations. But we're seeing this in a variety of areas. Two cases coming out of the Fifth Circuit that are set for argument this term. One about the Consumer Financial Protection Bureau, which of course has not been a favorite of conservatives, I think it's fair to say, since it was created. And this challenge, really interestingly, CFPB versus Community Financial Services Administration, is to the funding of the agency. So a number of agencies are funded in part or even in whole through fees levied on the parties who are regulated. And this, in fact, is one of the key criteria that scholars like Rachel Barkow have highlighted in describing an agency as independent versus more squarely part of the executive branch. The CFPB is funded in this way through fees, and the challenge is that this is unconstitutional. It violates the appropriations clause because it takes the power of the purse away from Congress and means that agencies no longer have to go back to Congress for their funding, that they're getting their funding in other ways. So this is really kind of getting at the legitimacy of these agencies and the way that they're constituted. The other case, SEC versus Jarkesi, coming out of the Fifth Circuit, cert was granted last June, coming at independent agencies, again, from several directions. This is a challenge to the SEC's structure and processes by petitioners who are subject to an SEC administrative enforcement action for securities fraud. And there are a whole variety of challenges here. A Seventh Amendment challenge, essentially a choice of forum challenge, a challenge to having the claims adjudicated within the agency as opposed to in the federal courts. A removal challenge, challenging the for-cause removal protection for administrative law judges, coming on the heels of the Lucia case. That was an appointments challenge to ALJs. And third, a delegation challenge, which is a challenge to Congress's delegation of authority to the agency to essentially choose whether to enforce the laws it's tasked with administering through agency adjudication or through district court action. The idea that there's no intelligible principle there to guide the agency's choice, and so it's essentially a delegation of legislative power. I mean, this is a hit list of all of the things, all the challenges that you would want to bring if you were highly skeptical of administrative agencies full stop, and especially of so-called independent agencies that have a little bit of distance and removed from the political branches. And the idea, I suppose, is that now is the right time to bring all those challenges.
Well, Sharon, you've touched on a host of issues there. There's a question in the queue that sort of gets to this sort of broader question about implications if some or all of these challenges to administrative agencies are successful. Questioners asking, what would the implications be of overturning Chevron? What would it mean for, as you said, the sort of previously codified guide rails that courts used in interpreting statutes delegating authority to agencies? They talk about our deference, but there are a number of other sort of judge-made rules, some of which have been elaborated on recently or more than others. But to your broader point, if some or all of these attacks are successful, and if the administrative layer is removed or at least limited, hobbled greatly, you're left with Congress on the one hand and judges on the other. And what does that world look like, where judges are essentially inserting themselves more, as you suggested, self-aggrandizing themselves in directly interpreting statutes?
I think it's even more dramatic than you suggest, Jay. I mean, I think that what we have here is actually a challenge not only to agencies' authority, but to Congress's authority to create agencies and to delegate tasks, or I would say even task agencies, with a lot of the authority that we've become so used to agencies wielding really since the founding. If you look at the work of some of Gerald's colleagues at Yale, Jerry Mashaw and Nick Perillo, talking about, agencies have been there since the beginning. Why? Because you can't administer a country without them. And so I think, the challenges are not just to what agencies can do, what kinds of claims they can adjudicate, how they can interpret their statutes, right? How they can interpret their own regulations. You mentioned but also to what kinds of agencies Congress can create. So that hobbles Congress and agencies, right? And who does that leave? Well, that leaves us with the court, of course. That leaves us with the president in some respect, right? In some areas, it limits maybe what the president can do through administration, which creates an interesting tension. But it leaves us with the courts and the states. So, it's a really interesting world to consider. And the fact is we may get to that world more quickly than any of us imagine, given what the court has on the docket for next term.
Well, I also should mention that Justice Thomas writes a concurrence in Sackett, where he has very narrow views of Congress's commerce power. And he said that the Clean Water Act is actually not based on substantial effects on interstate commerce, but on Congress's longtime ability to protect truly navigable waters. And that's the only source of authority. He goes on to say many environmental laws have been assumed to be based on the commerce power, but if his view prevails about how narrow that power is, there could be fundamental threats to Congress's ability to protect the environment through a whole host of laws, particularly the Endangered Species Act.
And I think that's the project, right? At least for some of the justices. So Justice Gorsuch, certainly Justice Thomas, right? I mean, Justice Gorsuch is very clear about this in his dissent in Gundy, which was about the non-delegation doctrine and a variety of other cases that, a smaller federal government is a better federal government. A Congress that can do less is a better Congress that better preserves liberty, right? In his view. And so all of these efforts, right, shrinking the authority of Congress under the Commerce Clause, limiting the ability of Congress to delegate to agencies, I mean, that's going to result in less legislation at the federal level, less for agencies to do. And the question is, what does that status quo look like then, right? What becomes the new status quo? It's not that there's nothing happening, right? Who's in charge? It's a lot of either states, right, stepping in to fill the gap. And this gets, I think, back to one of the questions that was in the queue about, what happens with wetlands after Sackett. States could step in to fill the gap or not, in which case it's private industry and private decisions that are shaping the future of environmental law in other areas.
And like former Chief Justice, the late Chief Justice Rehnquist, Gorsuch does seem to be fairly principled about the importance of protecting federalism. And I think that comes through in the pork producers decision. And also, I think one of the great things the court did last year was denying cert in all the state climate litigation in light of the oil companies trying to remove it to federal court. There have been at least a couple dozen lawsuits. There was a big one just filed by California, by cities, counties, and states suing the oil companies under state tort law, arguing that they violated consumer protection laws by deceiving the public about the implications of their products for climate change. And they tried to remove all those cases to federal court. They've lost in every single case. And on April 24th, the court denied all the cert petitions in those cases, which I think was a powerful indication of they're going to stay out of state tort law, which has traditionally been what the court did, was to stay out of state tort law. One couple of interesting footnotes to that, though. Justice Kavanaugh dissented from the denial of cert. So he may be much more sympathetic to the oil companies' views that the Supreme Court should just wipe out all this climate litigation because it's a global problem. And the other footnote is that Justice Alito apparently holds substantial stock in fossil fuel companies, so he always recuses himself in these cases.
I think the point that the point that Sharon made, which is really we really need to take seriously, right? Which is to ask, how are the powers going to be distributed among the various branches, right? And what kinds of things did the Constitution intend the Congress to do, right? And if their powers are constrained, and the non-delegation doctrine, of course, is one way to do it, but also, essentially it's a jurisdictional limit to the range of things they can legislate on. Well, that's it means we're in a new day.
Certainly for the federal government, and there are a couple of questions in the queue sort of addressing this question, asking the question of what this world looks like with regard to the states. Quite simply, are the states up to the challenge? Another questioner asking, are we just forever going to be reduced to this world of in the case of wetlands, pink and green maps on EPA's website about state authority to regulate wetlands, which was elaborated, I have to add, with some ELI research by my colleagues. are we forever going to be looking at these fractured maps, or is California going to become the sort of very large shaggy tail that's wagging the dog, which comes up? I mean, that's a concern. Certainly, Sharon, as you mentioned, in the pork producers case, but it's also taking place in the form of the arguments about the California waiver for the tailpipe rules. How does this landscape look going forward? And for that matter, isn't that the next pivotal case, the tailpipe cases that were argued in the DC Circuit about a week and a half ago, and that seem likely to land in the Supreme Court?
Yeah, I mean, there's so much to say there, and maybe I'll just start off the discussion by kind of increasing the complexity, right, of the problem, or maybe increasing the complexity, we don't want to label it a problem, of the scenario in which we find ourselves. Because in some ways, right, you'd expect the natural consequence of all the jurisprudence we've just been discussing to be that the states have kind of renewed vigor and power to pursue their individual plans, and we get kind of robust experimentation, all the goods that are supposed to come with state authority. On the other hand, you see cases like the waiver case that you were talking about, the question of whether California can impose its own more stringent emission standards from new cars and trucks under the Clean Air Act. You also have the issue of cities in California and the state even considering bans on new natural gas hookups in new construction, right? Both of which would seem to be consistent with this new narrative of state authority. And those are running into problems too. Right, so the waiver provision in the courts, right, is being challenged as unconstitutional, and that it gives California an unfair leg up against other states, right? I don't know whether that argument has actual legs, but it's being made in a serious fashion, even though the waiver was written right into the statute by Congress, of course. And in the case of natural gas hookups, the Ninth Circuit just invalidated the city of Berkeley's ban on new natural gas hookups and new construction, saying that it was preempted by a federal statute from the 1970s, the Energy Policy Conservation Act, which actually regulates appliances and their use of fuels, whereas this Berkeley ordinance regulates how natural gas comes into or does not come into property. So there are other ways to constrain state efforts that may not be favorable along particular dimensions. So I think it's more complicated even than just thinking about states and their renewed authority versus the federal government.
Other thoughts?
Sharon,
you keep dashing any rays of hope I try to throw out there.
Well, I was going to say, I mean, the distinction that Sharon drew between what the statute actually said and what the city was trying to do, I mean, those are not in alignment, right? But it's a source of power to regulate what these sub-national legislative bodies can do, right?
And it's a test case to see whether some of the commitments to federalism that we see in the Dormant Commerce Clause, and I think Bob's right, the quite principled commitments to federalism, whether those show up as well in the context of preemption and statutory interpretation. So that's something I'll be watching very closely.
Yet another set of constitutional issues, and drawing from beyond the environmental law arena, and this is something Bob, I think, previewed for us, teed up in last year's webinar. The Supreme Court decided the North Carolina and Harvard affirmative action cases, the very definitive statement about the long arc of attempts to create policy there. And it's clearly already had a chilling effect on environmental justice initiatives. I think that predated the actual decision, knowing that the decision was coming before the court. And there's also lower court litigation that seems designed to try to land squarely before these justices the question of EPA's authority for Title VI civil rights enforcement designed to implement environmental justice. So, Gerald, in particular, any thoughts on where that's headed?
No, I mean, one of the challenges facing this administration was how it would structure Title VI litigation, and whether there would be kind of an affirmative litigation, section set up in the ENRD to really do what private attorney generals cannot, right? Given the existing law. Well, given the potential interpretation or extension of the Students for Fair Admissions case, I think there's like two sets of concerns. One is whether the analysis, the 14th Amendment analysis they did in that case will in fact be the analysis that guides Title VI, whether it will bleed over into 1981 cases, and whether then that will affect the way private foundations or kind of sub-national units try to use their powers where federal funds are implicated, right? And I think we're going to be in a period when foundations, charitable foundations, corporations, are in a reevaluating the risk, right? I mean, the Biden administration in their EJ screening tool did that, before the opinions were even decided, by taking race out of the equation. And the reason they took race out of the equation is because they knew they'd be walking around with a target on their chest if they left it in there. And so, empirically, the question is whether they get the job done, given the tool they have. But now, with this case, is whether even if the federal government can't, how is this going to affect, activity of private actors? And I think the jury's out, but I think that people are reassessing the risk they want, the litigation risk they want to absorb. I mean, the other thing that it's done, of course, is it's given license for states to pass their own bills. So maybe this ties back to our federalism discussion. And there have been 89 bills passed in 28 states to limit affirmative action, to ban DEI training in government, higher ed, et cetera, to ban ESG investment, so that the movement on that front, that is I guess in some ways given more force by the Students for Fair admissions case. I think we're going to see both private actors acting more cautiously, and we're going to see state actors where they have the horses running aggressively to limit these initiatives. So my hunch is that what affirmative action activists will do will be to continue to challenge where they can, and likely at the state level, ways in which environmental decision making gets made to the detriment of identifiable environmental justice communities. But I think that hasn't changed yet, but who knows whether it will. And there certainly is a chilling effect that flows not just from the opinion, but kind of the shadow that opinion casts.
I've been impressed at how prepared EPA seemed to be for that decision, and had taken steps, like you mentioned, in the EJ screening tool. The president of our university announced that we were not going to let this decision have a chilling effect on our commitment to diversity. So they've actually changed the admissions application form, where it quotes directly from the opinion and says, Chief Justice Roberts said that clearly schools can still consider the impact of race and racism on one's total life experience. So it actually invites applicants to write an optional essay precisely directed to that, about how race and racial discrimination have affected their lives, which I thought was kind of a nice touche.
You can predict the next case, though, right? Which is you can't do indirectly what you can't do directly. I mean, that's the next case, right? That was the Fifth Circuit in the Fisher opinion, right? Which is, look, we say no, and any attempt to circumvent this decision, right, is going to be met with harsh repercussions. And so, you can hear the next case being teed up, right? If people want to, take the invitation that Justice Roberts offered seriously.
I do want to get back to audience questions. It's clear we could easily spend the rest of the time talking about Sackett. So many thoughtful questions here, actually, about the implications of Sackett. Before we get into those details, one more broad question, which I'll more or less read, but back to the topic of common law. Questioner writes, in the same vein as the shift of power to the states, some states are very lax regulators, let's say more lax than others, the maps we were discussing. But many environmental harms cross state boundaries. If the shift of regulatory authority goes back to the states, will this also open the door for more suits between states for environmental harms? Are we really going to go back to this sort of pre-1970 or early 70s world of state v. state and federal common law?
I mean, there's a reason the Congress passed those environmental statutes.
That has been my mantra lately.
I mean, they didn't do it just because they thought, oh my God, there's 20 million people marching for Earth Day. No, they were actually really hard, substantive problems that they were trying to address and to adjudicate or to regulate the competition between states and to pull all of those cases out of the kind of litigation that question, suggests. I mean, you can say, okay, these are just environmental pieces of legislation, but they were solving a lot of problems. They were solving a lot of problems that just resort to a federalism mantra is not going to go away.
Bob, any thoughts there?
Well, I mean, the federal common law issue comes up in all this state climate litigation where the oil companies are saying, because it's a global problem, it has to be governed by the federal common law of nuisance. And then they want to say, oh, we have this American Electric Power decision says that's all displaced by the Clean Air Act. But the courts just don't seem to be buying that. When the city and county of City Council Baltimore case was decided by the Supreme Court in 2021, at oral argument, the justices were asked to just forget about the technical removal reviewability issue and just preempt all this stuff. And even Justice O'Connor, whose father worked for Shell Oil, said that would be awfully aggressive of us to do. So for now, I think the state common law is still has the potential to be very robust in punishing actors who deceive the public about the environmental implications of their products.
Do you think the Suncor cert denial is likely to be the court's last word on that issue? They've certainly been fairly consistent in denying cert. The one time they did look at the issue, they raised a host of other possible ways there might be jurisdiction in federal courts and remanded to the lower courts to consider all those factors. But then those courts have been fairly consistent in not finding federal jurisdiction. Yeah,
because the federal removal statutes, the grounds that the oil companies have for removal are so incredibly weak. Their strongest argument is federal officer removal, where they claim that because they sell oil to the Defense Department, somehow the feds made us do it, and therefore, it should be heard in federal court. But no one's buying that. That's almost laughable. So they really, this is a strategy for delaying the inevitable trials that are going to be greatly embarrassing to them. And I've argued that this may turn out to be like the tobacco litigation, where the states all ended up suing the tobacco companies, and it resulted in this giant master settlement agreement of hundreds of billions of dollars.
Let's delve back just a little bit into Sackett, since there's so much interest in this and the Clean Water Act. So kind of at the top level, some of the biggest implications still unresolved of the decision. And Bob, you touched on this. What does it mean for Section 402 and discharge permits under NIPDES? As you pointed out, that the Maui case might seem to cover those, or at least provide an off-ramp for people who still want to enforce against pollution into streams, if not necessarily wetlands fill. And then another questioner pointing out that the whole question of tributaries still seems a little bit muddled and undefined in the wake of Alito's opinion, and that EPA's rule did not stretch too hard to try to clarify that, I think for fear of being too specific or being forced to be too specific.
Yeah, I don't see Sackett. I don't think the majority really directly addressed Section 402, but of course there's the problem that's illustrated by Maui, which is if you're not initially discharging directly into a water of the United States that's not a wetland, how far away can you be and still have a 402 permit required? Justice Breyer's majority opinion in County of Maui said that if it's the functional equivalent of a direct discharge, and he had this 7-factor test that only a law professor could love about how you decide what is the functional equivalent of that. I don't see anything in Sackett that directly implicates that. And you still have Kavanaugh dissenting in Sackett, who was in the majority in County of Maui. So but you know, the certainly Sackett will give comfort to those who think that the conservative supermajority is going to be open to some wild new interpretation that will create another loophole in the environmental laws. But in County of Maui, both Kavanaugh and Chief Justice Roberts were unwilling to do that. And it was quite obvious to them what was going on.
And what about this question of tributaries? Do we yet know what a continuous surface connection that may only be temporarily interrupted means? Because that seems to go to the question of waters as well as adjacent wetlands.
Well, that's what Kavanaugh raised in his dissenting opinion. He said there's all these unanswered questions now that this decision opens up. And I don't think the majority gave any real consideration to how those are going to be resolved. And it's certainly the case that in just about any case where there's any question about the reach of federal jurisdiction, Sackett will be raised, and it will be the new major questions to try to deter aggressive federal permitting activity in the future.
As to this issue of major questions, that's another issue that still seems to be, you know, just over the horizon, but clearly on its way to the court. It's been raised in any number of contexts ever since West Virginia was decided, and there have been some very novel district court decisions that are trying to apply it to a wide variety of subject matter. But the one case that really seems to be the next major test is the tailpipe case. I don't know how closely any of you follow the specific arguments in that case, but clearly they're attempting to draw an analogy to the beyond the fence line regulation in West Virginia, between that and going from regulating tailpipe emissions to electrification of vehicles. Does that seem likely to stand? It seemed like the DC Circuit was extremely skeptical, but then they just may be a pit stop on the way to the Supreme Court.
No, I think that's right, that it's a pit stop on the way to the Supreme Court. Certainly those portions of the Clean Air Act have been in existence for decades. And if you look at the Clean Air Act, there's never been a statute where it's been clear that Congress wanted to have EPA enact regulations of vast economic and political significance. You can't guarantee healthy air quality for the entire nation unless you do so. So it's a little disingenuous to suggest that this is a major new question where EPA or NHTSA are breaking new ground because they're regulating tailpipe emissions. We've been doing that for half a century now under the Clean Air Act. I think the administration's approach to encouraging a transition to electric vehicles through the carrot of providing financial and tax incentives is a great way of avoiding the claims that this is some new regulation requiring everyone to have an electric car. I now have had a totally electric car for 11 years. I'm now on my second one. I love it. It's been one of the great experiences of my life. And I'm really skeptical of whether these attacks on efforts to facilitate the transition to green energy are going to succeed. I saw Joe Manchin had an op-ed where he said the Inflation Reduction Act is neither red nor blue, but it sure ain't green. but it's certainly done a lot to facilitate the transition to renewable energy.
Yeah, I agree with Bob. I think that it's pretty easy to distinguish this major questions challenge from the one that the court found persuasive in West Virginia, and that here is really just EPA doing business as usual. And the fact that that happens to may produce more electric vehicles or alternative fuel vehicles, right, is beside the point. Like the nuts and bolts of how they're doing the regulation are, very similar, if not identical, to what they've been doing for decades and decades. And that my hope is that this new spate of major questions challenges that we're seeing, which is absolutely everywhere, right, in the lower courts as well as in the courts of appeal, is going to at least give the court the opportunity to refine that doctrine, and to double down on what I think of as the Roberts or majority version of that doctrine from West Virginia, which emphasizes not only the sort of scope of the question at issue, but also, how distinct it is, how distinct the agency's action is from what they've done previously, whether or not it's within their expertise, and this essential component of, are they trying to locate expansive jurisdiction in a really narrow corner of the statute, right? And I think that, you can say what you want about Section 111D, and I think they're very persuasive arguments that is not at all a narrow section of the statute. It was meant to be a broad catch-all to accomplish the purposes of the act. That's certainly, auto emissions regulation of the Clean Air Act. These are some of the core provisions of the statute. You see another example of the major questions doctrine in this case, which may make it to the court in the coming terms, Texas versus NRC, which is a case about nuclear waste storage, coming out of the Fifth Circuit, where the Fifth Circuit has just decided the Nuclear Regulatory Commission has no authority to license a private facility that is off the site of any existing reactor for the storage of nuclear waste. There's a major questions argument there too. It's essentially saying, like, storage of nuclear waste is a really big deal. I mean, I'm being a little bit glib, but not terribly glib in characterizing, I think, that argument. And so again, my hope is that, at best, this will give the court a chance to define the major questions doctrine in a way that makes clear that sort of the heart and the core of some of these traditional environmental regulatory statutes are not threatened.
Yeah.
Sharon, I go ahead, Gerald.
No, I was going to say, the point that Sharon made is really, really important, right? Because if you think of the major questions doctrine, right, and the way it's being deployed as really asking the question, has the agency illegitimately aggrandized its power in a way that Congress didn't intend? That's a different question, right? That's a different question. And that goes to the heart of agency management that doesn't tell Congress how it's got to write its statutes, right? And that's a big difference.
My favorite example of the absurd lengths to which major question arguments are being made is John Eastman is saying that whether or not he can be disbarred by the DC bar is a major question.
Well, it is to him.
And the fact is that, all of the environmental statutes that we have, certainly all of the big statutes that we teach in our foundational courses that we've talked about here today, they all deal with major questions. So if that is the version of the test, which is more the Gorsuch version, I would say, than the Roberts version, if the subject matter of the regulation is major enough or its effects are major, if that is the test, anything an agency does under these big environmental statutes would qualify, because we're dealing with issues that affect everyone, that affect our environment, that affect our economy. That's just the nature of the regulatory program. So it can't be that, right? It can't mean that. And I don't think that that's what West Virginia said either, but we need more detail about what the guardrails are.
I think you're exactly right. I think it can't mean that, right? And, to a point you made earlier, I'm not the last time, but a couple of times ago, which is the nature of the problem that Congress is attempting to address, right, requires Congress to act in the way it's acting, right? They're not passing a statute that regulates crossing guard hours, right? They're passing a statute that, will implicate, lots of different parts of the economy, but also, that has a lot of science that it's got to be implicated as well. And, the statutes are necessarily going to be drawn to solve the problems that they identify. And that's the key issue, it seems to me.
And that's another Justice Kagan's refrain. She says, I think on more than one occasion, broad language does not necessarily mean vague or ambiguous. I think we may have to leave it there. We're running out of time, but this is also a good way because I think it is previewing what is doubtless going to be probably the headline on our discussion next year. So we can just keep daisy chaining these issues for better or for worse. Thank you all very much. I greatly appreciate the discussion, your different perspectives and expertise. I would love to do it again next year under whatever circumstances we're finding. And Madison, are there any other sort of housekeeping to do?
No, not particularly, but I just want to echo what Jay said, and thank you so much to our wonderful speakers for taking the time to join us for this outstanding discussion on such an important topic. Thank you to Jay, Sharon, Bob, and Gerald. We so appreciate your insight and your expertise. And like Jay said, we hope to see you next year to see how all of this turns out. For those who were watching us live, today's event was recorded. So if you were unable to watch all of it, you'll be able to watch the recording on the event webpage within a couple of business days. We also posted the links to the other 2 relevant ELI webinars from this summer about SACIT and about the revised WOTUS rule in the chat. So if you found this webinar informative, we encourage you to check out the recordings of those programs. Thank you to our audience for your time and for all of your wonderful questions. Please be sure to check out eli.org for more information on all ELI programming. We hope to see you at a future event, and have a great day, everyone. Thank you again.
Thank you.
Thanks again, all.
Thanks, everyone.
Good seeing you guys.